Trial Lawyers University, where the Titans come to train. Produced and powered by LawPods.
Well, this is quite the honor today. We have the legendary trial lawyer, Spencer Lucas, from the PSR firm. And Spencer and I have been knowing each other going on, we were thinking about more than 8 years. How about that, Spencer? You could be the longest known person other than Raleigh on our agenda this year. So Spencer,
I've been learning the wisdom from Dan Ambrose for a while now. So thanks for all your help along the way, Dan.
You got it. In 2016, Spencer came to one of the first Trojan Horse programs in Marina Del Rey, California. So what was that like for you, Spencer? Because little did I know at that time, Spencer was already a pretty accomplished trial lawyer. Had been part of many big cases, especially one is the AC Transit case up there in Oakland, California, because we did a case analysis on many pieces of that case after the fact. And when you break down a trial and watch somebody in trial in the courtroom, you can really get an appreciation for their skill set. And even though my favorite cross of that case was Panish crushing, what's his name, Clemente Jones?
Clement Jones, Dr. Jones.
But Spencer had some big moments of that. I mean, it was the most interesting cross movement of an economist. And it was like talk about making an economist cross interesting. Spencer Lucas did it. So if you ever want to see that, it's on TLU On Demand. But Spencer, what was like that? Just give us because that was a long time ago, 8 years ago. So you only made it for like a day and a half of that course before you had to get called off to trial in Vista. So what's your memories of Trojan Horse?
I don't know if you remember this, but you and I met at Conal Doyle's birthday party. And I was telling you guys about a trial that I was starting in a week in Vista. And I was kind of giving you like a little opening, and you stopped me and you said, Spencer, I'm doing this clinic in Marina Del Rey. It's called Trojan Horse. You should really come. And I thought, well, hey, I always want to learn more. And this guy, Dan, seems pretty smart. So I showed up. And do you remember you convinced me to get up in front of the whole room to do this little experiment where you close your eyes and you think back to a traumatic moment, something that really stuck with you. And I told you guys a story about
hold on, in Cuba.
That's
I remember the story about Cuba. Something that happened, like you were stuck somewhere, like in an airport or something, weren't you?
Exactly right.
That's
ran
amazing.
out of all my money after living there. I gave all my US dollars to my Cuban friends, and I thought I could get back to Mexico, not knowing that there was an exit fee of $18. And I'd already checked my luggage. All I had were my sandals and the Guayabera on my back. And I was super tan, had a long beard, hadn't spoke English in a long time. And no one believed me that I was just an American kid trying to get back to Mexico. And so finally, this nice Canadian man saved me and gave me the money to get back through the customs. And so you had that be the little experiment of storytelling. And there were a lot of great lessons in Trojan Horse, and you still teach them today.
Well, it was a good start. It gave you a lot of foundation. I got to meet lots of people like you, and get some experience in the area. And I think it really obviously put me in a good position when COVID came along to start this platform, because at least I had a few people who knew who I was. So that was a big start. But let's talk about your start, Spencer Lucas. You weren't always an LA guy, living La Vida Loca in Santa Monica or South Bay. Once upon a time, you lived in the great Northwest. So tell us about that and how you managed to meander your way down to PSR.
That's right, Dan. So I'm from the Northwest. I grew up in a small town out on the Olympic Peninsula called Port Orchard. It's basically a ferry ride away from Seattle. And Port Orchard, the locals say, there ain't no port and there ain't no orchard. But it was a lovely place to grow up. And it's basically, a Navy town. My dad worked at the shipyard his whole career, and my mom worked at a printing company. So a lot of good quality values growing up in that type of environment. And I never knew any lawyers, didn't have any lawyers in my family, but my great-grandparents came from Scotland, and somehow they ended up in this little town of Port Orchard. I don't exactly know how, but my great-granddad became one of the first lawyers in our county. And my little spitfire of great-grandma, 5'2" lady from Glasgow, she became one of the first female judges in the state of Washington. And she was basically the justice of the peace. deciding the cases. And so I would hear these amazing stories of these immigrants coming to our country, and they didn't have any money, but they worked their way up, got an education, and they used the law to help their community. And so I think those stories stuck with me somehow. And by the time I was, in junior high, I really knew that I wanted to be a lawyer. And I didn't know what kind of law I was going to practice, but I knew that the law had the ability to help others in our community. And that's what really drove me.
So you decide at a young age that you want to become a lawyer. So how do you get down to, why LA? How do you get down here or there?
So growing up in the Pacific Northwest, I only applied to sunny weather schools, and I applied to Pepperdine. And my Huskies, I went to University of Washington. In the year 2000, we played in the Rose Bowl, and I road tripped down and I checked out the Pepperdine Malibu campus. And I said to myself, hey, if I get into this school, I'm going to come down here. And sure enough, I did. And it worked out. And I really loved my time at Pepperdine. And I got a job when I was in law school. And they ended up hiring me out of law school. And it was a small firm in Brentwood. They did a little bit of everything from insurance bad faith, construction, real estate. And when I was in law school, I wanted to do real estate law, maybe entertainment, something kind of cool. And I tried a little bit of that, and it wasn't meaningful at all. I did some cool real estate projects and things like that, but the clients were always complaining about the bill, and I really felt no true value in what I was bringing to the world. And I was a second-year lawyer, and I remember I was doing my taxes on Lincoln Boulevard in Santa Monica at the H&R Block, and my nice little accountant lady, she was in a full arm cast, full leg cast, typing up with one hand, and she was crying to me about how she got hit by a drunk driver who ran a red light. And her husband had cancer. He was totally disabled. She had 3 young kids. And the drunk driver had a big insurance policy, and they weren't paying the claim. And she didn't have a lawyer. She was handling it on her own. And she was about to be foreclosed upon. They were going to lose their family house. And so I'm talking to this nice woman, and I said, hey, I'm a young lawyer. I've never done a car accident case, but I think I can figure it out. Why don't you let me help you? And so I took her case, and I got all the medical records. I wrote up a nice demand letter. And within about a month, I got this family the full insurance policy. And she came into my office with her husband in a wheelchair, brought her kids, and they brought me a plate of cookies. And, the lady's crying, telling me how we saved her home from foreclosure. And I thought, this is what being a lawyer should feel like. I mean, it's not my biggest case ever, but this is what I want to do with the rest of my life. This is what being a lawyer can and should be. And so I started to actively focus on learning more about personal injury, and I really found a calling there. And, the way I met the guys from the firm is kind of funny too. So I signed up to be a member of CALA, our local consumer attorneys group here in Los Angeles. And
so let's just stop there for 1 second, Lucas. That's how I got to California. So in 2012, because it was my 45th birthday. Raleigh invited me to come out and watch him speak at CALA in LA. It was back at the Palazzo, and I don't know, it was like 2012. So it was a great start for me. I don't think we met at that point, but I could see like, hey, this is a very vibrant legal community here in LA. This is a lot more fun than Detroit. That's to say the least. So, but you were about to tell us how you met Brian, how you got connected with PSR and really meeting Brian Panish.
Yeah, so you're right, Dan. I mean, you've always done a great job of networking, and I think it's so critical for young lawyers especially to put yourself out there, to meet people, and just do whatever you can to network. And that's what I was doing as a young lawyer. I had a job at this law firm that I enjoyed, and it was about 2006 at this time. And I didn't know any of the players in the industry, didn't know anything about who the Panish firm was. I knew nothing. But I went out there and, I'm kind of networking, and one of my friends introduces me to this, big guy, and we're talking college football, drinking Coors Lights. And I wasn't intimidated because I had no idea I was talking to the great Brian Panish. And so we're talking football. I may have talked a little bit of smack about the Fresno State Bulldogs, whoever they were. And I must have made an impression on him, because later that night, I'm sleeping because I want to get up early and go to the conference. And my wife and her friend were downstairs gambling, apparently with Brian Panish and Victor George. And they asked, "So who are you here with?" And my wife says, "Oh, Spencer Lucas. He's a young lawyer." And Brian replied, "Oh, I know that guy. I met him today. He wears a lot of gel in his hair." My wife tells the story better than I do. But that's how I first met Brian, and he had just started his firm. And I got connected with Adam Shea at that same conference. I signed up to get a CALA mentor, where they match a young lawyer with a senior attorney from CALA. And ironically, I got set up with Shea. And so he and I started communicating, and they had just started the firm, and they needed a Spanish-speaking lawyer, because it was just, Brian, Adam, and Kevin back then. And they were just about to hire Rahul, and they didn't have any Spanish-speaking lawyers on the team. And one of my friends said, "Hey, this guy Spencer is actually a fluent Spanish speaker. He's lived in Spain and Mexico and Cuba. And even though he's a total gringo, he does speak Spanish." And so, we ended up talking, and I met with Brian and Adam, and Brian was like, "Hey, tell me some Spanish." And I did my best to convince him that I did speak Spanish. And next thing you know, we were off to the races, and that was about 17 years ago.
That's a great start. That's a great start. You're talking about, networking young lawyers, and I think that's really so important, because as most young lawyers or law students are really clueless about what they want to do with their lives, and about becoming personal injury lawyers. And being that you get to the great Pepperdine law school, one of our goals here at TLU 2024 is to get 100 law students there. So we're working on giving out 100 law student scholarships, Lucas. So make sure that when we're done with our podcast, you get in touch with your people at Pepperdine, because Glassman is supposed to get in touch with people at Southwestern, and Rahul at Loyola. So that way we get more LA law students there, which would be really great for the future, because they need to learn skills, and they learn how to network too, and be exposed to what their futures could be. So let's keep that in mind for going forward. Because great too, because then they can actually, the whole mentor thing I was thinking about too, if there's a bunch of people from LA there, well, then they're going to get to meet, people from your firm, the Vardazarians Fair, all these Connell Doyle, all these people that are coming out and teaching, and a much better chance to get connected and learn what they're doing. So
that's really great, Dan. And yeah, I've already reached out to Pepperdine, and I anticipate that we'll get a good group of people coming out for this.
That'd be great. That would be great. Investing in our future here of justice, future of justice.
That's right.
So you got started with PSR over there. So tell us about your first jury trial with Brian Panish.
So my first assignment with Brian was working on a case that was going to trial in El Centro, the Teresa Gonzalez versus Dressick Farms case. And mind you, I knew absolutely nothing really about trying a personal injury case. And Brian took me under his wing, and he was as patient as he could be, given my stature. I knew nothing. And he basically said, "Hey, you're going to drive this van with executive presentations down to the Mexican border with all of our exhibits, get everything set up, and start working on the opening keynote." And I asked him, "What's a keynote?" And he had to describe to me that we use Mac computers, and there's a program called Keynote, and that I better figure out how to use it. And so, I did my best in trying to, figure out how to use Keynote. I'm making phone calls to tech people, and I stayed up 2 nights in a row. Brian gave me all the exhibits and his handwritten outline and everything. And I basically stayed up 2 days in a row, worked myself literally into a fever. And mind you, it's August in El Centro. It's 110 plus down there, so hot. And I'm in this air-conditioned room for 2 days straight, trying to put all the slides together. I finally get it done. It's serviceable enough that Brian accepts it. And I remember going to watch him give the opening statement, and I'm just like shaking with a fever. I'm in the back, and I'm like nodding off. And Brian afterwards is like, "You don't look so hot, Lucas. Go back to the motel." But Brian ended up getting a tremendous verdict. At the time, it was the largest verdict in Imperial County history. And, we love that community down there. It's hardworking, and we've had a lot of success based on what Brian started way back in, what was that, 2008, 2009?
Well, not everybody has a mentor, Lucas, and not everybody gets a mentor named Brian Panish. So since you were fortunate enough to be in that position come the fates of the world, what would you say are the top lessons, that have really stuck with you from being exposed to BP for these last 16, 17 years?
So I've been very fortunate to have Brian Panish as my mentor throughout my career. And there's so many things that stand out. But if I had to really narrow it down to three, I would say they are preparation, aggressiveness, and authenticity. Because Brian prepares like you've never seen. I mean, when he gets an expert designation, he immediately starts devouring as many expert depositions of the defense doctors as he can get his hands on. I'll see this guy leave on a Friday with boxes of materials that he'll read through all weekend. He gets up early in the morning, reading stuff, sending us emails. When he's in the gym, he's poring over materials while he's on the bike or the treadmill. Late at night after dinner, he's digesting and synthesizing information, coming up with themes and ideas. And he leaves no stone uncovered. I mean, this guy is an absolute animal when it comes to the preparation. So he leads from the front, and I've never seen anything like it. Rahul is almost at that level, and I've seen him do the same thing. But those two guys together, I mean, it's incredible to watch, and it really rubs off on all of us. But the level of preparation is truly unparalleled. And the next thing I'll say about authenticity. I mean, you see Brian, he's got this, when he walks into the room, they say the barometer shifts, right? I mean, he's just got this persona and gravitas that is truly authentic to him, and no one else can do it like he does. But what Brian teaches is that you have to be authentic to yourself, and no one can try to imitate Brian. I mean, if someone did, it would just be stupid, right? I mean, I try to do my little impression of him,
No,
but
it's very entertaining. I love your impressions, Brian. I often do one. It makes me laugh, my own impressions, but yours are better. You got more practice, though.
I mean, but in the courtroom, right? It's about being authentic to who you are, right? And I've got my own style, and I can't try to be like Brian or be like Rahul, but Brian teaches that, hey, you just got to be yourself, and it doesn't have to be perfect. We all make mistakes. We all slip up our words sometimes, and it doesn't always have to be pretty or perfect, but you do have to be authentic to yourself, and you have to be authentic to your client and to the story. And that's something that Brian does really, really well. He knows who he is at his core, and that shines through, and that really creates a huge amount of trust with the jury because they know he's the real deal. And he's not trying to fake anything. I mean, it's just straight up the truth. And so Brian does that very well, and that's a great lesson for everyone. And then the last thing is aggressiveness. The aggressiveness that is required in cases like this, you really have to take it to the next level. And it starts with the early discovery in the case and creating pressure any way you can. Any way you can gain leverage on the defense by immediately meeting and conferring when you get discovery responses, by immediately filing a motion to compel and asking for sanctions, by setting up all the depositions, forcing their hand, and keeping the pressure on. A good defense is a better offense. And so we always need to be on the offensive. And I remember one of the first jury trials I did with Brian, it was downtown LA. We got a really nice verdict for a kid with a TBI in the Tilton versus SoCal gas case. We got a great verdict, and I'm expecting a high five out in the hallway from Brian. But he just looks at me and he says, grab a pen. And I start writing down the to-do list. He didn't have a smile on his face. He wasn't elated with the verdict. It was all about drafting the judgment, the game plan for fighting the post-trial motions, analyzing any potential appellate appeals, getting our cost bill in order. And there was no hesitation on what to do next to keep the pressure on, even after the verdict. And that was a moment when I realized, this is how it should be done. it doesn't end when you get a big verdict. We're going to keep going and keep the pressure on until our client is fully vindicated. And so that level of aggressiveness is at every turn. And Brian does a great job of helping all of us prepare so that we can bring that aggressiveness that is required to make these cases successful.
Right. And your firm, you were like what, lawyer number 4 at your firm? Is that right? Number 5? Where were you?
Well, it was the 3 partners, and then it was Rahul, and then it was me. So I was the second associate hired at the firm.
And now you guys have what?
For me, certainly.
Well, for sure, because we got like 50 plus lawyers now, or right around that neighborhood. Is that right?
Yeah, we're growing all the time, but yeah, we're close to 50.
That's pretty awesome. And, and it's quite a team that, you've assembled over there. Because I was counting the other day about, because people often discuss GOATs, of course. And I'm like, I said, there's a lot of great lawyers, but only yours is the only firm I know that has I counted 8 lawyers that I know that had 8-figure verdicts, but they're probably more than that because you got a lot of people there. But that's pretty impressive to keep that team together. You know what I mean? To not only just build a team, to coach a team, but to win championship after championship. Because a lot of times, these teams win a champion, which is what, verdicts, big results. People get championships, they want to go into free agency and, see what the market has to offer. But apparently staying with the winning team is better than the free agent market at PSR. So, which is pretty cool. That's a
great sports analogy, Dan. And one thing that really helps our firm, I think, is just the camaraderie. We constantly share ideas, and it's a big team, and we work together, we collaborate. When we do trials, we'll combine teams, we bring in help, and we're always helping each other, and we have fun while we're doing it. So we've had a good run, and we're going to keep on going.
Yeah. And, I got such the benefit during the pandemic because I got to really know so many people from your firm, because you and I probably did half a dozen webinars, but same thing with Glassman, Shea, like even if Stump, he's not with you anymore, but I got to know him real well. Just so many, not just the Panishes, the Sheas, the Ravipudis, the Lucas that did, but I met so many of your younger lawyers, and they're all just, top-notch people with, we're just so great to work with, right? Because I do these webinars and stuff, and it's a lot of preparation. And, people are like, and the people are already busy still, right? It's not like Panish is like, hey, you're prepping for a webinar. Just take a little time off early today and do a good job. It's like, you kidding me? It's like do all your work and do all this stuff. So, I really appreciated that and the preparation and get to know so many, cool people and good people from your firm.
Well, Dan, you really get it, man, on the preparation level. And I will say, during the pandemic, every time we did a webinar and you'd call me and you'd say, hey, Lucas, I need 4 hours with you and Panish to prepare for this webinar. And I would think to myself, seriously, Dan, we need a half day just to prepare for this thing. But then, we'd sit down with Roger Dodd or whoever it is we're doing the podcast with, and we're spending time going through it and analyzing the material, figuring out the best way to present it, how to streamline it and make it effective. And I learned so much just during the preparation component of the webinars. And I think that shines through to what we do as trial lawyers, where you end up learning so much about the case and the medicine and the engineering, all the components of the trial. If you actually put the time in, like how you teach, Dan, it ends up making the whole experience so much more valuable.
And fun, frankly. And, just, from my perspective too, it was kind of like, I was like, when else am I going to get all these great lawyers to mentor me? The pandemic, it all worked out. It really, I know it was a difficult time for a lot of folks, but I am very grateful for COVID. And, it is what it is, right? You can't stop it. So you might as well adjust the sails and do what we can with it. So Lucas, let me ask you this. You've had a pretty good career so far, good run, poised for even greater things. But what would you say, what accomplishment professionally, as a trial lawyer, are you most proud of?
The accomplishment I'm most proud of as a trial lawyer, Dan, is back in 2020, out here in California, they passed Assembly Bill 218, which gave survivors of childhood sexual abuse the right to file claims that were otherwise time barred by the statute of limitations. And we had done some work in that field over the years, but it wasn't a huge focus for us. And with that legislation passing, we started opening up the firm to doing these cases on a broader scale. And we started working on cases against religious institutions, youth organizations, and other institutions that were notorious for covering up decades of childhood sexual abuse. And so I sort of spearheaded this effort at the firm and started working on these cases. And I've devoted a huge part of my practice to helping these survivors. And it's totally different than doing a personal injury case. Because in a PI case where someone is catastrophically injured and they've got medical bills and lost wages, oftentimes they have no choice. They have to bring a lawsuit, otherwise they're going to be destitute. But in the case of these childhood sexual abuse cases, these survivors have to find their internal strength to come forward and seek justice for themselves. And there's a huge emotional component to that. And so over the past, say, 5 years, I've really been focusing on these cases, and we've been able to help hundreds of people who were brave enough to come forward and stand up for themselves. And we've had some tremendous verdicts in the field of childcare, and obviously against school districts, and even some amazing results against religious institutions that, for me, it's less about the monetary verdict and the amount of the award or the settlement, but it's really what happens next in terms of these institutions finding out about these results, and it's shining a light on the darkness. And there's a ripple effect, there really is, where it creates changes and policies and procedures, and it creates awareness that our community, our jurors, they're not going to tolerate these cover-ups. They're not going to tolerate school districts, for example, turning a blind eye to a notorious teacher who had multiple accusations against him and allowing him to continue to be around kids. Our communities won't allow that. And so it's been incredibly satisfying for me as a lawyer to be a part of this awareness, and also the strength that our clients have found in finding their own voice and standing up for themselves. And it's just been very gratifying to be a part of that process and help our clients get along that path of healing.
Well, we're doing TLU Vegas, October 16th through 19th, and one of the tracks there is going to be the PSR track, which I'm super stoked about. As well as Nick Raleigh, the trial by human track, Sean Claggett, the Claggett Sykes track. Joe Fried and Satch Oliver are teaching for 3 days, and this has really been as far as for me, I'm really super stoked about it, because when I first met all of you guys during the pandemic, there were certain lawyers and law firms that basically were doing things in a certain way that I got to witness over and over, and getting consistent results that were so far above the curve that it was, but it was the processes. And in my mind, it was like these people, your firm, obviously Claggett, Paris included in there, who has a great, system, a lot of great lawyers, and Raleigh. I'm like, God, it'd be so great. You guys should have your own trial programs. Of course, I mentioned that to Panish back in 2020. Ambrose, Paris, he's a professor. I try cases. Get him to teach. I'm like Panish, but you built all these great trials. Ambrose, I'm not the professor. Get the professor to help. I'm like, okay. But so having you guys all come together I'm really fired up about that. But you in particular are teaching a breakout workshop, case framing roundtable on sex abuse cases and helping people with theirs. So tell us about that, that workshop and what you want to share with people and how you're going to help them.
Yeah, Dan, thanks so much for allowing us to be a part of this TLU in Vegas. We're all super excited about it. I'm going to do a breakout on childhood sexual abuse, focusing on strategic considerations, everything from marketing and intake all the way through trial. So we're going to break down and have a collaborative discussion, focusing heavily on discovery and everything that you need to find notice evidence, deposition techniques and strategies for the key witnesses the person's most qualified and the institutional witnesses that are necessary to win a case like this. We're going to talk about cutting edge developments in expert testimony and how to find the right experts for a childhood sexual abuse case. We'll talk about preparing for a trial and what we can do in terms of focus groups to assess the case, find certain themes, how to analyze the damages components, and create real life examples of the trauma with the non-economic damages to get the maximum result for the client. So it's basically from an A to Z analysis of the sex abuse cases, collaborative discussion, and strategic implementation so that we can all help each other get the best results for these clients.
And speaking about getting the best results for the clients, I think that your most recent trial was with BP on a sex abuse case. Is that correct? Is that still your most recent trial, or did you do one after that?
That's right. We've been very close on a bunch, but they seem to be settling on the courthouse steps. So yeah, the most recent one was with Brian out there in Riverside.
All right, and so let's talk about that case because that case had some challenges. So let's just kind of give us the overview nutshell of that case to put it in context, the discussion.
The case was called Brady Blair and Justin McGregor versus the Moreno Valley Unified School District. And Justin and Brady, when they were in the 6th grade in 1996, their teacher was a guy by the name of Thomas West, who groomed them and groomed their parents and ended up molesting them over a period of about 4 years. And what we were able to determine in discovery is that the teacher, Thomas West, he had a foster child who had run away in about 1991. And he went to the police and he told the police that he was being molested by Mr. West. So the teacher was arrested and he was let out on bail. And the teacher went to the principal and told him that his foster kid had made allegations of child molestation and that he was under criminal prosecution. But he said the charges were not true. And so the principal said, we're going to go along business as usual. This is a personal matter. And so the district turned a blind eye to it. They didn't hear about it again, so they thought the charges were probably dropped, but they weren't. What happened was the teacher ended up pleading out to a lesser charge of child endangerment, and he was doing jail time on the weekends while he continued to teach the 6th grade. Now, the district claimed they didn't know about that until way later when the teacher, every 2 years, they have to renew their teaching credential in California. They submit all the paperwork. And when he did that in 1995, the Teacher Credentialing Commission, they said, well, wait a second, you've got a criminal conviction on your record for child endangerment. Your license to teach is immediately revoked. And so the district sent the teacher a letter saying, hey, we found out about this charge against you, you're out. Now, what we proved in the trial was that the school principal, he wanted to support the teacher and that he believed the teacher that the charges were fraudulent from some crazy foster kid with psych issues. And so the principal held a meeting with all the staff and all the teachers at the school, and he encouraged them to write letters of support to the Teacher Credentialing Board in Sacramento so that the teacher could get his credential back. And sure enough, what happened? The teacher got his credential back. They let him come back to the school with no extra supervision, no investigation, no nothing. And that's where he met our 2 clients and he got his hands on them and he severely abused them over a number of years. So the case did have some hurdles. And
well, hold on, Spencer, let me ask you though, but let me ask you though, what were the hurdles? Because I want to ask you about like the trial of it too and your approach to it. So, but what were the hurdles you had to overcome?
There were a lot of hurdles in the case, starting with the fact that all of the abuse happened off campus. So what this teacher ended up doing is he basically isolated the 2 smartest kids in the class, our clients, Justin and Brady. And Brady, his dad, was also a 6th grade teacher at the school. So he was co-teachers with Mr. West. And they became best friends. And so all of the abuse of Brady was off campus, where Brady's dad would let him go on off-roading trips and camping trips with Mr. West, the perpetrator. And so there was an argument that Brady's father, who actually knew about the foster kid charges, but he believed his friend that he didn't do it. So there was an argument that the dad was at fault for letting his child be around Mr. West. And then with respect to Justin, it was even harder because Mr. West, he found out that Justin's mom was going through a divorce. She was newly divorced, and he started grooming her as well. He started dating Justin's mom. He ends up moving in with Justin's mom and Justin, where he abused him on a nightly basis, basically under the same roof where Justin's mother was. And so the defense really argued hard on Justin's mom. And they said, hey, look, she admitted that she knew about these charges from the foster kid, and she just believed Mr. West that he didn't do it. And yet and still, she invited him into her home. She let her son be around Mr. West totally unsupervised. She allowed them to go on camping trips for the weekend together, even after she knew about the allegations. And so the defense was trying to blame Justin's mom for what happened to him. And they argued the evidence code in California under the argument that any off-campus abuse, they're not responsible for. So the fact that all of the abuse happened off campus, that was a big hurdle for us. The fact that the parents knew about the allegations and they continued to let their kids be around this guy, that was a big hurdle. We also had some difficulty with respect to Justin and Brady both because they were extremely successful in their careers. You know, oftentimes we have survivors of childhood sexual abuse that, you know, become alcoholics, drug addicts, they're unemployed, they're on the street, they can be homeless, and their life is in shambles. Well, Justin and Brady are both extremely intelligent. Brady ended up going to law school. He didn't quite finish law school, but he got into cybersecurity, very smart with computers and programming and networking. And Brady is a very high-level cybersecurity expert from Microsoft, does a lot of very high-level consulting. And Justin, he went back to school and got his engineering degree, graduated top of his class, and he's a high-level manager for a manufacturing company doing high-tech engineering work. So the defense was able to argue, hey, look, these guys, you know, they're doing pretty well. They've got good jobs. They're very successful. You know, how badly harmed are they? And also, Justin had never sought any psychological treatment or therapy whatsoever. He had a long-time steady girlfriend and a healthy relationship. And so it was difficult for us to assess how to create the damages story, especially considering that neither of the plaintiffs, Justin or Brady, had any damages witnesses to speak of. So they had no friends, no family members, no spouses, no therapists, and we weren't able to present any damaged witnesses in the case whatsoever. We really just had both the plaintiffs testify, and we had an expert psychologist for each plaintiff. And that was it. But kind of because of their psychological trauma, both of them became very isolated. And that became part of the story, that the reason they don't have any friends and family members to testify is because they were so withdrawn and their personality was stunted. And they had a problem trusting people, letting their guard down, being vulnerable, and engaging in deep, meaningful relationships. So we own that part of the story. And there were also some difficulties, you know, Dan, in all these cases, the defense hires an expert psychologist to do the defense medical examination. And more times than not, the report comes back and they say your client's malingering, right? Now, Justin is a very stoic man, and he did fine on all the testing, no signs of malingering. Brady had a more difficult path, I'll say, and he did have a lot of psychological issues from the trauma, and he ended up failing the malingering measures, not only from the defense doctor, but also from our own expert. And that's always a challenge to overcome. But what ended up coming out in the testimony from the plaintiff expert and the defense was that Brady over-reporting symptoms It was simply a cry for help. And he's so badly damaged, and he views himself so badly damaged that he wants to get his point across that he's not okay. And it was really more of a cry for help than him trying to over amplify any of his symptoms. But those are some of the hurdles that we encountered in the case, which are not uncommon in these childhood sexual abuse cases. We see these as themes in many cases. And thankfully, through the help of the clients and the experts, we developed the game plan and we framed the issues the right way that we were able to overcome those in trial.
Well, let's speaking of framing the issues in the trial, because I was involved a little bit with the case because you guys were doing a focus group on this case in Vegas. But the mini opening, what kind of, when you do a mini opening in a sex abuse case, what is it that you're trying to accomplish with it? Especially like this case right here with all these issues you just talked about. So how do you lay those out, in the mini opening to set up the voir dire?
The mini opening, Dan, I'm glad you brought that up because I got to give you some credit. You were very helpful for Brian and I. As you remember, about maybe 6 weeks before the trial, Brian and I flew out to Las Vegas. We met with you in our mock courtroom and you helped us practice the mini opening. And we had maybe 20 jurors or so come out, mock jurors, and we practiced the mini opening. We videotaped it. We worked on our posture, our tone, our hand movements, the phraseology of the key themes that we were using in the mini opening. And then you helped us with the back and forth with the jurors. And that was really, really helpful for us, not only in the mini opening, but also as we went forward to jury selection. But for the mini opening specifically, what we try to do is, first off, we'll do a focus group, an online focus group where we get a bunch of data and we find out the parts of the case that potentially could be problematic. And for us, the biggest hurdle was the fact that all of the abuse happened off campus. The second biggest hurdle was that the parents of each boy knew about the allegations against the teacher and they didn't believe him and they let their kid be around the perpetrator. So those were two huge issues. And then the third issue, for Brady was the malingering, the argument that he was exaggerating and this is just a big money grab. And then lastly is the non-economic damage, the money, right? We're trying to test what the amount of money in terms of our ask, what would be appropriate. So those were the four big topics that we wanted to handle in the mini opening. And there were a few others as well, but those were the four primary. And so in the mini opening, we're not trying to win the case in the mini opening. And some people make that mistake where they think it's their first chance out of the gate to make a great impression and lay out the best case. And I think we all have that natural instinct, right? Because we want to do a good job and we want to win. And so it's counterintuitive. But for the mini opening for us, what we're trying to do is plant the seeds of the defense arguments to see which jurors latch onto that. And we utilize that to get cause challenges. So also, for example, in a case like this, we're suing the school district, right? That's a public entity. The community taxes go to support the district. And that's a big item where jurors come in and we wanted to get that out there in the mini opening that obviously this is a public entity school district where we're asking for more than $100 million. And you know how many hands get right up out of the gate when we ask the question like, ladies and gentlemen, this is a case against a school district where we're asking for more than $100 million. Who here feels a little uncomfortable that this is just a non-economic damage case, no medical bills or lost earnings, just the pain and suffering, the emotional distress. And we're asking for more than $100 million from a school district. Who here feels a little uneasy about that? And so many hands run up. And thankfully, we had a jury questionnaire that the judge allowed. So we already had some background intel on who these jurors were, how they felt about non-economic damages, how they felt about us suing the school district, right? And so that really enabled us to start the conversation with the jurors and really open up a candid conversation where they let out their biases.
And so, but to start the conversation, to set up the mini opening, can you just kind of give us like your, what basically is, what you said to them, and so that way kind of like Because I know it's like, what, you got 2, 3, 4 minutes to lay those things out to them.
Yeah, so we would tell them about the case, kind of like I did at the beginning, where this is a child molestation case, and I don't go into the severity of the trauma because that could have a tendency of flushing out jurors that are good for us. But we say this is a childhood sexual abuse case that occurred in 1996, where the sixth grade teacher was accused of molesting these children. The evidence will show that the district knew or should have known that this perpetrator was a danger to children. And in this case, there will also be evidence that the parents of each boy knew that the sixth grade teacher previously had an allegation of childhood molestation made against him, and yet they continued to allow their child to be around him. The evidence will show that nearly all of the abuse happened off campus, off of school grounds. And at the end of the case, after the witness testimony, you'll hear about the damages in the case for pain, suffering, emotional distress, humiliation, damages, loss of quality of life, diminishment in the ability to trust others. And at the end of the case, on behalf of my client, Brady Blair, I'll be asking for an award in excess of $50 million. Right? And so we lay it out like that. And just in a very short mini opening, they're hearing public entity, off-campus abuse, the parents are to blame, psychological damages only, pain and suffering, money grab, and they're hearing $50 million for one guy, right? And then, Brian and I both represented separate clients. I represented Brady, Brian represented Justin. And so we both got a chance to do the mini opening. We both got a chance to do jury selection. And I got to tell you, it was super fun because most of the time, picking a jury, you're up there on your own and you've got maybe some help with your team and the jury consultant, but it's just you. And when you have a partner like Brian Panish batting cleanup or vice versa, where we're like, oh, let's really pin this person down, it's a really fun way to try a case. And we were able to do that. And the law allows for it. We had 2 separate clients and, Brian was more than willing to jump in. And I was so grateful to have as a colleague there, Brian Panish, doing the jury selection with me.
I bet you were. And so speaking of jury selection, tell us about some of the, how you framed, some of the key issues in this type of case. Because, this isn't, like you said, this is not a PI case. It's very different issues. So how'd you talk about some of these, some of these things?
Yeah. So the first and most important, as I mentioned, was the fact that we're suing a school district. And people in the community, they obviously have many concerns about how it's going to be paid. Is this going to take chalk off the chalkboard? Are my children going to be affected by a big verdict? And so most of our cause challenges were geared in some way towards the school district. But what we also found is on the non-economic damages, there was an overlap where, this judge allowed us to say specific dollar amounts in jury selection and in the mini opening, where I said 50 million for Brady, Brian said 80 million for Justin, and that's exactly what we asked for in the final argument. And the jurors, one juror in particular, she, this is like day 2 of the jury selection. She was really tough to get on cause challenge, but she came back the next day and she raised her hand and she said, I just couldn't sleep last night thinking about $130 million, and it made me sick to think that a school district might have to pay $130 million for something that occurred in 1996. And where's that money going to come from? That's going to hurt these kids in this community. And it's just for pain and suffering, emotional distress. And I just don't think I can do it. Right. And so she came out of the gate really laying it out there. And sure enough, there were some other jurors that raised their hand and they say, yeah, I feel the same way that Mrs. Smith does. I don't think I can do it. I just, no matter what the evidence is, I just can't do it. So those 2 issues really became instrumental, the school district and the large amount of money that we were seeking compensation for. And one technique that we use in cases where we're only seeking non-economic damage, we say, hey, look, this is not a case where we'll be presenting medical bills or lost wages or any sort of receipt or invoice that can be reimbursed. This case is only about the physical pain, the mental suffering, the anguish, the humiliation, the anxiety. It's only about those non-economic damages that there's no receipt for, that you're not going to see in black and white. And who here feels just a little bit uneasy, a little uncomfortable that, we're asking for a lot of money, millions and millions of dollars for just these pain and suffering, emotional distress type damages. And then the way I phrase it is I don't say who is against those damages or who doesn't believe in those damages or who thinks they're wrong, because that requires a more solid commitment. I just ask, who feels a little uncomfortable here? You're going to get more hands if you do it in not a full commitment, but just a little uneasy, a little uncomfortable. I don't quite know about that. And then a lot of people are going to raise their hands. And then by the time you get one juror really coming down hard and saying, you know what, I'm not buying it. No matter what you show me, I'll never be able to award your client $50 million, no matter what the evidence is, and then we kind of lock them down with the right phraseology of, okay, so are you telling me that you can't be entirely neutral on this case because of the type of damages that we're talking about? And they're like, yes. And then I double down, maybe say something like, okay, so, if this were a foot race and the district lawyer's here and the plaintiff lawyer, me, I'm right here. Are you telling me that because of the type of damages we're seeking, that I'm starting off just a step behind the other side, that we're not starting off on a fair and level playing field? Yes, that's how I feel. Okay. And so you're telling us that this is just not really the case for you, given your personally held beliefs, right? Yes. And to the extent we can, based on the questionnaire or based on the jurors' commentary that they give us, we try to connect it to some sort of personal history with the juror. Whether they have, okay, well, Mr. Ambrose, you have kids in the Moreno Valley Unified School District, is that right?
Yes.
Right. And so is it going to be in the back of your mind that if we get a sizable verdict north of 100 million, that it's going to affect your children and affect their education in a negative way?
Yeah.
And so
Right.
no matter what we do in terms of presenting you the evidence, are you going to have a hard time coming up with the full value based on the evidence because you'll be thinking about your kids?
Of course. I mean, I got the personal connection there, and constantly lowering the threshold for people to, opt in, just, that kind of stuff there.
That's right. That's a good way to phrase it. We're trying to get people to opt in and use just common sense things, because sometimes the judges, even if you get the phraseology right, if you're putting words into the juror's mouth, the judge can say, well, yeah, they said it, but, you were kind of leading them, and it was they heard what Mr. Smith said and they're just trying to get off, but I'm not really buying it. So to the extent you can loop it back to something in the questionnaire that ties them to the case. Well, I noticed on question number 37 on how you feel about these emotional distress damages, you said very against, and you wrote something in the margin. What'd you write in the margin? And that says way too high. Okay, well, why'd you write that in the margin, right? And that might just be a little tee up where they give you more information about their personally held feelings. And so you need multiple different quivers in your bucket of ammunition for the judge when you're arguing these cause challenges. So that's why we try to double and triple down on this.
Oh yeah, I was with BP up there at that trial during COVID with the heat stroke up in, I think it might have been Riverside too.
San Bernardino,
but because Panish would literally go at the person 10 different ways for his challenge for cause. I'm like, Panish, I think you got the guy. He goes, Ambrose, I like to put cement shoes on him. You know why? Because we drop them, they're not coming back. We can't have them come back. The cement shoes, something like that. So it was like locking him in because obviously that's something critical to get rid of those bad jurors, because you can't get a good verdict with a shitty juror, or a biased juror. So you get the right jury. And
let me say one thing about the jury selection, Dan, too, that's interesting here. So Riverside historically is a conservative venue, right? We know that there's some big verdicts that come out of Riverside, but if you think about the demographic, it's a lot of blue collar, it's somewhat diverse, but it's historically been pretty conservative. But what we found in these childhood sexual abuse cases is it doesn't matter. You can try these cases in any venue because even the most conservative jurors, they want to protect kids just as much as anyone else. And when there's a situation where an institutional defendant is involved in allowing a child predator to be around kids, they will absolutely drop the hammer, and that they're not afraid to give a big award. In fact, in this Brady Blair and Justin McGregor case, we had a full-on Trumper juror who was wearing a MAGA hat. He had a big beard like ZZ Top, like truck driver, old guy coming in, just hard as nails. And, you know, my instinct was, oh man, that's going to be my first strike. Get this MAGA dude out of here. But, you know, I remember during mini opening, I'm looking at people using the Ambrose technique. I'm trying to make mini contacts with everybody. And when I'm laying out just the basics, and they weren't even the greatest facts, but that the district knew or should have known that this perpetrator was a danger to the kids. He was like, danger to kids, right? Like his face kind of changed. And after the verdict, he stuck around and he was our very best juror. And the jury ended up giving us $5 million more than what we asked for. And it was his idea. So you never quite know. And these childhood abuse cases, they're totally different than a standard PI case. So it does make picking a jury a little bit more nuanced. And you really have to talk to each person and find out how they feel about the facts and just all the different nuances in your case.
And Sonia Chopra, was she up there with you for this
She was.
jury selection? And so tell us how, I know she's pretty much, from what I've seen, what I know, the trial consultant for PSR. I mean, all the cases I've worked on, seen, she's there. She's like ubiquitous. So tell us how Sonia kind of helps you and BP, or in general, but in this case, you know, find the right jury.
We've been working with Sonia Chopra for many years, and I can't remember how many trials I've done with her, but she's a psychologist, and she really understands the human condition, and she understands people, right, better than anyone else. So you can't just judge a book by its cover, right? I mean, we watched the jurors come in and we're like, oh, this panel looks pretty good. What do we know, right? But Sonia's picked more juries than anybody. I mean, probably more than 1,000, I would guess. And she knows that you have to speak to people and you only have a limited amount of time. And so you better do it in an effective way. And you got to let them talk. You have to listen. You have to use active listening. And as trial lawyers, we have a tendency of talking too much. We love to hear ourselves chatter on and on. In jury selection, it's the opposite. You want to say as little as possible and make people feel comfortable, put them at ease, and get them talking, right? And empower them to tell you their truth and disarm them a little bit and just be like, say, it's okay. You know, tell me how you feel. You're not going to hurt my feelings. Okay. Tell me how you feel. You think I'm a greedy lawyer asking for money on a case like this? I can take it. But, you know, this is important for me, for the clients, and for you as a potential juror, as an American citizen. So Sonia teaches these techniques and strategies of phraseology that disarm the juror and make it more comfortable for them to talk about their biases, right? And so Sonia's done a really great job. And she also helps us earlier in the case in terms of framing the case. We'll share with her our data from larger online focus groups. She helps us synthesize that and come up with ways to frame certain issues. We'll go through the opening statement with her. We'll practice in front of her, and she doesn't hold any punches. She gives us great critical feedback. We're great friends at this point, and Sonia's really done a fantastic job for our clients.
So when you say the big data stuff, I think you guys use, is it Kristen Ove to do some of your big data studies over there at PSR?
We do use Chris. Yep, he does a great job. And so in the Blair case, I can talk a little bit about the focus group. We did many, and it started out where we were testing the the liability side of the case and all these kind of problematic areas, how jurors felt about the off-campus abuse, about the parents knowing about the perpetrator allegations, about the potential malingering issue. So we tested all the different things, and we were able to kind of realize in the focus group that the big issue was the fact that the perpetrator was the wrongdoer. And this guy, Tom West, was serving out the rest of his life in prison for what he did to these two boys. And so the common defense is that, hey, this perpetrator was a master manipulator and he should have all the fault. And why are you going to blame the school district when this guy is an intentional wrongdoer, a predator? He did this to the boys. He's going to be on the verdict form, and you should give him 90 to 100% fault. And even if you find the district was negligent, that they could have done better and probably should have done better, let's just give the district, 5 to 10% fault, but it's really the perpetrator who's in prison. This guy owns all the fault. And the focus groups, they bore that out. And I think it was, 50% or 60% of the fault was on the perpetrator. And so we had to come up with a way to frame the case appropriately to maximize the percentage of fault on the district. And so after focus grouping it and refocus grouping it and tweaking the themes, the way that we framed it and it ended up working was kind of twofold. Number one, we told the jury right from the opening statement that this is not, and I know we're probably going to get to opening statement next, but this is not a case about Thomas West. This is a case about the school district and their total failure to protect our kids when they knew one of their employees was a danger to children. This case is about the district. Now, Thomas West, he's serving out the rest of his life in prison. He's doing his time, and he will for the rest of his life. This jury, what you're going to consider, it's not about whether what Thomas West did or did not do, his negligence. It's got nothing to do with that. We know what he did was wrong. We know what he did was evil, and that's why he's been criminally convicted in a criminal court, and he's serving time in prison. This case is about the school district, and you'll hear evidence that the school district knew he'd been arrested for allegations of child endangerment and child molestation. There will be evidence that the district knew that he was convicted of child endangerment and that he got his license revoked by the California Teacher Credential Commission. And even after that, the school district lobbied so that he could get his credential back and he could keep teaching in the school. And the only reason that was possible is because the district enabled him and they empowered him and they helped him get his license back. And if they would have owned up to their obligations to protect our children, they would have fired this guy back in 1991. And so we framed the case in such a way that we were heavily focusing on the district and separating it out from the perpetrator. And we didn't have the perp come into court, even though we could have. We got a stipulation with the other side to streamline the case. And we said, hey, look, we deposed the guy in prison. We've got his video deposition testimony. Let's designate it. I'll do my cuts. You do your cuts. We'll play his deposition in the trial, and we'll save some time that way. It'll be easier on everybody as opposed to getting a court order and having him bust out to the Riverside courthouse. And so the defense agreed to that. But part of the effect of that was that he wasn't sitting there every day. He was a named defendant in the case. The school district cross-complained against him. But the jury was sitting there looking at the defense lawyers and their risk management representative in the back. There wasn't a guy in an orange jumpsuit sitting there every day. So he wasn't fresh in their minds. And from the very beginning, we were hammering the fact that this case is not about West. He's already admitted what he did to these boys because he admitted it in the deposition. He admitted he abused Brady, admitted he abused Justin. He did say Brady was a big fat liar and that he only did something to him like twice. But, it didn't matter. He admitted the abuse. And so focusing on the district and not the perp was one of the big things that we learned in the focus group. And then we started that off right in the opening statement.
And speaking of the opening statement, and just kind of give us a overview of like how you approach these openings. When you bring up, obviously, when do you mention the plaintiffs? Did you talk about the amount of money that you were looking for? Do you play? I know from past experience, your firm does a lot of video depth clips that you play and stuff. So kind of just give us how you guys put this opening together.
So Brian and I each had the opportunity to do opening statements, Brian for Justin, me for Brady. And we did them in a different stylistic format. And Brian's was a little bit more fire and brimstone, right? Focusing on the district. And, he did the whole thing. This case is not about the perp, it's about the district. And mine was a little bit more formulaic, and I used a roadmap timeline because there was a lot of data points that can be kind of confusing when you're talking about, all right, first complaint in 1988, second complaint in 1991, then he was arrested again in 92, criminal thing, and there was a lot of data. And so we put together a really visually compelling roadmap that looks like a roadway. And we had the different dates pop up. You've probably seen it, Dan, where the different evidence, the documents and exhibits would pop up in the roadway. And so at the end, it was a very clear, literal roadmap of the notice evidence to the school district. And I remember after I went through that, this is what the evidence will be in the case. This is exhibit number 17. This is a letter when the district suspended Mr. West for sex crimes against children. Right. And then going down the road. And then this is 1996 when Justin and Brady were in the 6th grade class, left alone with this perpetrator. So the visual timeline was really important. And then also we really like to use divergent timelines in any case where there's an allegation of comparative fault, either comparative fault on the plaintiff, or in this case, it was a huge argument of comparative fault on Justin's mom. Again, she allowed the perp to move in with her. And so the divergent timeline, if you've seen it, we have green boxes up on the top. And this is everything that a school district must do to protect children. What are the 5 steps they must do always? And it's adequately screen the teachers. Make sure they don't have a criminal record. If there's any complaints, they need to be thoroughly investigated. If it's a credible complaint, the teacher must be removed away from the children. Simple, right? Every logical person reading that would have to agree with all 5. And then below that is the red divergent timeline. Well, what did the school district do in this case? Number 1, they knew about complaints and they didn't do anything. They went along business as usual. And that was the quote that the school district lady said, business as usual. And no investigation. They didn't even interview the perpetrator. And what did they do after his credential was revoked? They went on a lobbying campaign and they got all the teachers to write letters of support. He got his credential back and they put the perp back in the classroom around our 2 clients. So every single thing they did was wrong. And so we developed this sort of a comparison of not just one act of negligence, that the district was negligent in retaining the teacher. It's boom, 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 boom. We had like 12 different independent acts of negligence. And when you compare that in terms of comparative fault against Justin's mom, well, look, she was manipulated by this master manipulator, just like everybody else. And she's not a teacher. She doesn't have the training that the school district teachers do. She's not a mandated reporter. This is some poor mom who went through a nasty divorce and she's manipulated by a district employee. And you're going to try to blame her, even though the district was the one that suspended this creep and helped him get his credential back. And so when you compare the negligence, the jury said, no way, she's not negligent. And they gave her 0%. So in opening statement, we utilized those 2 things, the timeline of the different events and then the divergent timeline, along with deposition clips. In this case, I did the depositions of the defense experts. We had the school district policies and procedures expert named Rick Schmidt that the district hired. Really nice guy. He's a former superintendent, former athletic director, big sports guy. He thinks he's the man. And, I was thinking to myself, what's this guy going to testify to? And of course, they don't produce his file on time. In California, they're supposed to produce the expert file 3 days before. I don't want to lose the trial date, and I've got so much ammunition. I'm ready to do his deposition anyway. Finally, like 10 minutes before the deposition, they do a data dump of his whole file. I'm ripping through it, and I've read all these documents so many times, and I see, oh, wait a second, what's this? I haven't seen this record before. And sure enough, it's the smoking gun record that they've been hiding from me for 2.5 years. It's the suspension letter from the district in 1991 when the district found out that his teacher credential had been revoked. And they write, "Dear Mr. West, we found out that you were convicted for allegations of sex crimes against children. Your license is summarily revoked." And they were trying to hide that piece of evidence, but it ended up in their expert file, and I got it that way. And so once we had that, it was, I questioned him about it and said, "Sir, you would agree that in 1991, the district fell below the standard of care in failing to fire Mr. West." And he, long pause, yes, right. So he admitted negligence of the district in his deposition, and we were able to play that in the trial. And then the other expert they had, it was a lady named Adrienne Meyer, who is a very nice psychologist. She makes a very nice appearance, and she did the medical examinations of both of our clients. And part of what these doctors do, Dan, if you haven't encountered this, in California especially, they do testing for depression, anxiety, PTSD. They typically use a test called the MMPI, the Minnesota Multi-Inventory, and the PAI, these different psychological tests, right? Well, the way that these tests are graded is it's a computer software program, and the program spits out a report without any input from the doctor. And so both of our clients, they filled out the form online, they did all the testing, and then boom, the defense doctor gets the computer generated report. Now, defense experts, they don't like to turn this over, and they try to claim that it's proprietary and they can't turn it over for legal, ethical reasons. And that's a bunch of BS. That's not true. It's not accurate, and it's not fair to us. And so we always fight for that. And we say, yeah, we'll give you an examination. We won't make you bring a motion before the trial judge to get the exam, but you have to give us all reports. And what these reports end up saying is, based on the reporting from the plaintiff, the following diagnoses should be considered, like severe PTSD, depression, anxiety, sleep disorder. This patient is at significant risk for suicide. This patient is at risk for immediate inpatient treatment, all these crazy things. And so meanwhile, the doctor's opinion is, well, I think they have some sort of adjustment disorder, but it likely is due to the family trauma because the parents were crazy and the parents, did corporal punishment on the boys as kids. And this person has all these other things throughout their life that are causing the adjustment disorder. It's not the fact that they were raped for 5 years by their 6th grade teacher. And then you cross-examine them with the report on the data, and they just can't deny it. They try to wiggle out of their own report, but they can't. So we were able to get a lot of great concessions from the defense psychologist, and we played both her testimony and the liability expert from the district in our case in chief. And I think it was pretty helpful.
I imagine it was. So speaking about your case in chief, though, let me ask you, though, in your opening statement, did you give the jury a number that you were going to be asking for in your closing, or did you just leave that kind of open-ended?
We did. I think I said at least 50 million for Brady, and I believe Brian said at least, or something like in the range of $80 million. And so it may have been just a little south of that. Like we may have said at least 45 million for Brady. But in the final argument, we asked for 130, but we definitely said a hard number. And I think it's imperative to do that in a strong case where you have good evidence. If you have the chance to say a number, but when we're talking about it in mini opening, we're talking about it in jury selection, we're talking about it in opening statement. By the time we get to the final argument, they already know. They already have an idea of where we're going with it. And now it's supported by all the overwhelming evidence.
The so the opening. So we finish the opening. So I want to talk about in this kind of case. I want you to tell us how you think about the order of proof and how you're going to prosecute the case because you got this great evidence. So how do you sequence it for the maximum impact?
The order of proof is critical, and we spend a lot of time game planning and strategizing how we're going to present the evidence. And so more times than not, we like to start off right with the defendant. And that's the first witness out of the gate, and the jury sees them, and they might be a little critical in the way they're thinking, and hopefully they'll be critical about the defendant. Now, for us, we don't want the perp anywhere near the front of our order because we don't want the jury even thinking about the perp. We want the jury only thinking about the school district. So our first two witnesses were former school district employees. The first was a teacher that was Justin and Brady's sixth grade, I think, literature teacher. Nice old lady, been retired for a long time, but she was helpful because she talked about the fact that the principal hosted this meeting where he requested all the teachers write letters of support so that the guy could get his credential back. And the district denied that. And, they claimed that didn't happen. But this teacher, she was like, yeah, I remember the meeting. How many people were there? Well, the whole staff, there's probably 80 of us. And who requested the meeting? Who was in charge? She's like, oh, the principal, Principal Kuzmik was his name. Okay. And did the principal, and this is Brian who did this examination. It was great. And did he get up and ask everybody to do something? She's like, well, I don't really recall. It was something about writing letters for West. And well, did you write a letter? She's like, yes, I did. And so this lady admitted that she wrote a letter of recommendation so that West could get his credential back. And that's how we started it off. And it was basically, we're kind of proving a cover up here that this school district knew about these allegations. They knew that he got his license revoked. And yet the principal encouraged all these people to write letters. So that teacher's name was Betsy. She went first. And then the next one was the principal himself. And this guy, during discovery, he evaded service and he's retired down in San Diego. He looks like George Hamilton, super dark tan, white hair, like white suit, like real like fancy guy. And Brian did a fantastic job with his cross-examination. So we serve him with a trial subpoena. He shows up downtown Riverside. He's sitting out in the hallway across from Brian and I, and he's got like a notebook with notes in it, and he's like writing things down, and okay. So he takes the stand and he ditches the notebook out in the peanut gallery. And of course, Brian, first thing, he's like, so I see you had a notebook. What's in the notebook? Oh, just my notes about the case. Yeah, all the meetings I've had with the lawyers. Okay, and they told you what to say? Yeah, and those notes that you're reading, they refresh your recollection on how to testify here today? Oh, yeah, sure. Pursuant to Evidence Code 771, Your Honor, I'm going to ask that Mr. Lucas grab that notebook. Granted, I grabbed the notebook, started reading through it. It's like meeting with lawyer. And it was like all these details about what the lawyer told them, how to testify. And I mean, it like something about Betsy, the teacher, how she said there was the meeting and he played dumb, like he's like, oh, I'm old and this and that. And then the papers that he was writing on, Brian pointed out, he looked at it down on the backside of it. It's a betting website, like super complicated golf betting online. And so meanwhile, this guy's playing senile, yet he's highly involved in these online golf betting programs. So he just got eviscerated on the stand, and Brian crossed him like one afternoon, had to come back the next morning. And he basically admitted that, he knew about the allegations. He didn't think they were true. He did no investigation, and that he encouraged the teachers to write letters of support. So we started the presentation off focusing heavily on the district. And then I think right after that, we played the defense expert deposition that I took, their liability guy, Rick Schmidt, where he admitted that the school district violated the standard of care in not firing the teacher back in 1991 when they first knew that he was arrested for child molestation accusations. And so from there, we pretty much had liability locked up when their expert had to admit it. And, which, by the way, I should comment, Dan, that, that the district fought liability from the inception of this case all the way through jury selection, mini opening. They're arguing liability. Brian and I both do our opening statements, hammering the district's failure to accept any responsibility since 1996 when this first happened, all the way up until now. They've, refused to accept any liability. And then the first thing the defense lawyer does when he gets up there after seeing us, we want an opening statement, right? And to answer your earlier question, we do try to win an opening statement. But in this case, we did, because the defense lawyer, he got up there and was like, well, wait a second. I agree. In 1991, we probably should have done better, and we probably should have fired him in hindsight. But that wasn't the cause of the trauma. So even if we're negligent, which, look, I kind of admit we are negligent, that's not the cause of their harm. Really, the cause is the parents. And so they were fighting causation. So even though they ended up accepting negligence in the opening, they weren't accepting liability. So that happened. And so after we put on the expert video deposition, then we switched over to damages, and we started to put on both experts. And as I mentioned earlier, we didn't have any family members or friends or anything. So we had Justin's expert, who was a psychologist from Los Angeles named Bennett Williamson, who testified beautifully about Justin's PTSD, his depression, his anxiety, and how it's affecting him on a day-to-day basis. It was very impactful. And then Brady's expert was out of my home area in Washington, Gig Harbor, Dr. Dooley. The guy kind of looked like Sigmund Freud with his beard and glasses. And he testified by Zoom, which actually, it was very effective. And I don't think we lost any momentum or value from having this witness testify by Zoom. He did a very nice job, and he handled the malingering argument quite well, as a cry for help, essentially, like we talked about. And after the two experts went, then we ended the case with the plaintiffs. And Brady was harder to deal with than Justin. And so we wanted to end on a strong note with Justin, knowing that he was going to be able to, keep his composure and handle himself on cross-examination. Brady was just more challenging and was more combative in nature. And we were a bit worried about how he would handle the cross-examination from a very skilled defense lawyer. But Brady ended up doing great and was tearful on the stand, expectedly. And then our last witness was Justin, who was very impactful. So they both were so brave in their testimony, and they got through cross-examination totally unscathed.
So I imagine it's quite difficult to prepare a witness like Brady and Justin for the stand, from what they've gone through, what they have to talk about. So kind of just give us a snapshot how you go about that process, dealing with somebody so traumatized and dealing with stuff that was 30 years old.
These cases are so hard to handle in terms of helping the client navigate the deposition, the defense medical exam, let alone a trial. And for us, everyone on our sex abuse team has trauma-informed training, because it's just required. If you're doing these type of cases, you have to be educated on how to delicately help these clients through these difficult legal proceedings. And so for me, with Brady having the most difficulties, I spent a lot of time with him before his deposition. We spent a full day and a half together, spread out over some time. but probably 14 hours of prep for his deposition spread out over a number of days. And it starts with the client trusting the lawyer and really developing a relationship so that they trust you and feel comfortable with you, because a lot of these clients, they don't trust people. And, in this specific situation, they don't trust men that could have a position of authority, right? Given the fact that they were abused by their teacher, Brady didn't trust men in general. And so it took me a while for him to open up to me, to trust me, to know that I have his back and that my job is to protect him. And then it's just making sure that they're in a good mental space and that they're safe, because I knew that Brady was suicidal at times, and I knew that he had issues with dependency. And so making sure that he's safe, we got him a safe place to stay, and we got through his deposition okay. But it started there, and then for the trial, we started working with a jury consultant, someone that, she spent days with him, with another attorney, Matthew Freeman from our office, practicing, and also practicing what it felt like to be cross-examined by an artful lawyer who can be a little aggressive, because we didn't want the first experience for Brady being grilled in cross-examination to be in front of the jury. And so we had to practice that. And Brady has a lot of anger issues. And so we had to get him into a space where he felt comfortable enough and confident enough that he could tell his story. And if he was peppered with cross-examination, he wasn't going to blow up, because anger in front of a jury from the plaintiff is never a good idea. We want the jury to get angry on their own. We want them to feel the anger, not the plaintiff. And so it took a lot of help by our wonderful jury consultant, Donna Sears, and all of our team in prepping both Brady and Justin.
So you guys get through your case. What kind of case because it seems pretty overwhelming, and you already got the evidence for the best witnesses. So, what kind of case did the defense mount here?
So they couldn't call their expert, Rick Schmidt, because he admitted the school district violated the standard of care. And so the defense lawyer, he told us that they weren't going to call him, and their only witness was going to be their psych expert. And we had already played her video depo clips in trial, where she made a lot of great concessions about the sequelae and trauma from childhood sexual abuse. And so I'm preparing at like 11:30 at night for the cross-examination of Dr. Meyer. And we had some really great ammunition that Brian and I had compiled. And the defense lawyer calls me on my cell and says, "Hey man, I know you're up late working to cross her. We're not calling her." And I was pretty disappointed.
At least that was pretty considerate to stop wasting your time.
Yeah, he's not a terrible guy. So what they ended up doing, Dan, is they abandoned their experts, and they simply played some additional clips from the perpetrator's deposition from the prison, and they rested after that. So that was their strategy going in. And, we were able to expose the power to produce stronger evidence that they could have called these experts, and they didn't, because their experts support our position. And we played their video evidence in our case in chief. So who's bringing you the truth?
So I don't need to ask about your closing, because I could really well picture it based upon what we talked about, but I'm just dying. Like, what did the defense say in their closing? And did they? I know you guys asked for 130 million. Did they suggest a number?
So the defense's closing was that they said, "Look, we could have done better back then in 1996, and that was a different time. That was like early days of the internet, where it's totally different than what we have now, and we know differently now in 2024 than what we did in the 90s. It's just a different time. This whole concept of child sex abuse is much more at the forefront after the clergy scandals and everything else. We know about it now, and we do differently now, but back then we didn't know. And yeah, we knew that he had an arrest from this foster kid situation, but we didn't know that he was convicted and was doing time on the weekends. And when he got his license revoked, there's really no evidence that we did anything wrong. He was exonerated by the California Board of Teacher Credentialing. And there's a teachers union and they control who can teach and who cannot teach. And anyone in the state of California that has a license, they're automatically fit to be a teacher. And he was exonerated in Sacramento from those charges. And so once he had his license back, it was reasonable and appropriate for us to allow him to continue to teach. He'd been teaching in our district for many, many years. He was teacher of the year. He was the favorite of all the students. And we just didn't know. No one believed that he was a threat. I mean, even look at Justin's mom. She knew about these allegations and she moved in with the guy and she let her kid be around him. Who knew Mr. West better than his own live-in girlfriend? I mean, if anyone's to blame, she should have some responsibility here, right? So they made all these arguments, including the fact that all the abuse was off campus. And then they fought causation really hard. So even though they said, yeah, we could have done better in 91 when we should have fired him, but it really wasn't the cause of the abuse. The intervening cause was the fact that the parents let their kids be around this guy. So obviously the jury wasn't buying it, and it didn't go well for them at the end.
Did they suggest a number though?
They did, but frankly, Dan, I think it was so low that I don't even remember what it was. They asked for a defense verdict and they put up some number, but it was so low, it's not even registering in my memory right now.
So at the end of the day, tell us what the jury does. But I never asked you this: is what happened? Like, what was your offer before trial?
Yeah. So it was in mediation, so I don't think I'm able to disclose it, but it was shockingly low. It was the amount of money that you would expect on a fender bender soft tissue case with no medical bills. It was absurdly low, in the six figures for both guys.
So the verdict comes back at 130 million. And so what's any comparative?
The verdict came back at 135 million. With
that's right. Because you gave five more than you asked for.
With a 90% finding on the school district. And with respect to Justin's mom, who was on the verdict form, the jury found no negligence. So yeah, that was the verdict. The parents were totally vindicated, and that was a huge win for us.
And so you get this verdict. I know that's just that's just the first step in truly getting a case resolved. And this is a public entity. And so I was wondering, can you talk about how the process you guys go about, because it's great to get a verdict, but that doesn't put the clients whole. Doesn't mean shit. Everybody says you can't spend a verdict. So how do you guys go from there to putting the pressure on to get the case resolved and, get paid? Because that's the whole point here.
Right. So in this case, the insurance was pretty interesting, and we'd taken some person most qualified depositions in discovery on the coverage. And so the district really was covered by an entity called SELF. It's a school excess liability fund. In California, they call that a joint powers authority, a JPA, or a pool, where these different school districts come together and they pool their funds, and it acts like insurance, even though it's not necessarily governed under insurance law. And so prior to trial, we had demanded what we believe the full insurance policies to be, which at the time was approximately 28 million for both clients, 14 million and 14 million. The district laughed at that. They said we were going to lose the case, whatever, and they offered peanuts. So we had to go try the case with a minimal offer on the table, and it never increased. The offer never increased, even up until the point where we gave final argument, rebuttal, and then it started to become, okay, I think they're going to offer it was either 14 or 15 million in terms of the coverage total. And, the clients didn't want to take it. And so
they did offer the 15 million, right? They offered 15 million.
They did offer what they claimed the policy coverage was, and the clients turned it down. And thankfully they did, because they got a much better verdict. And so we mediated the case afterwards. It was several months later. There was some post-trial briefing, and before the hearing on the post-trial motion, because we were a little, there's a concern anytime the jury gives more than the ask. that starts to become a question. But we worked with Holly Boyer, the appellate attorney, who does a great job in this field of sex abuse cases. And we had all the legal briefing worked up. We worked with insurance lawyers, experts in the insurance industry, and we mediated with Robert Kaplan, and we got a mediation done.
So the case has been resolved.
It sure has.
Great to hear. So Lucas, if people want to get a hold of you, what's the best way to find Spencer Lucas?
The best way to get a hold of me is to email me, s.lucas@panish.law, or you can call me anytime. My number is area code 310-477-1700.
Great. All right, Mr. Lucas. And if anybody needs to get a hold of me, obviously my email is dan@triallawyersuniversity.com, and my cell is 248-808-3130. Oh, one more thing. We got a webinar coming up, don't we? An analysis, like a real in-depth analysis on this.
We do. The date, though, it was moved, so we got to check with your team on when that date's going to be. But
I thought we had that date. I thought you picked that date.
I did, but then it got moved, I guess.
Oh, well, that's because you're such a busy guy, Mr. Lucas. You got all these trials and depositions, all this big lawyerly stuff you do. Now speaking at national conferences is another thing. So we're just really excited that you're coming out here for Vegas with your whole team. And I know our webinars on the schedule because because that's how we got to really, we knew each other a little bit before the pandemic, but we really got to know each other a lot via Zoom. It's amazing how much time we spent. And what's great is that all that, we didn't really know at the time, but like all that content that we did, all those breakdowns that we did, it's like now they're, all on TLU On Demand, which is now an app for your phone, the whole platform. You can find, you can access all of it on your phone. And, we collect all the pleadings, transcripts, and PowerPoints for all these cases. And so it's like this really great library for trial. And so we do this one, somebody that watches it will be able to read all these depositions you talked about where you crush these experts and stuff, like to actually, when people are working on these cases, to actually be able to read how, somebody that's, really experienced, like you and Panish, are doing their depos and setting up these PMKs and setting up, these jury questionnaires, because, the questionnaires and the voir dire, they all work together with the trial consultant because you got to get the right jury to get the right verdict. So I'm just like, pretty happy with all the content that we did create because it's all there for people to learn. So many different ways, and all the work you guys did with Dodd on cross-examination and stuff, and having him, break down your cross, break down Panish's cross. I mean, it was a great time to be learning, and it's all there. And so we're going to be creating more content, everything we do in Vegas, because there's 9 tracks, and people always complain to me, oh, I've got FOMO, I'm going to miss this, I'm going to miss that. I'm like, you're not going to miss anything. It's all on TLU On Demand. They're like, yeah, but that's a subscription service. I'm like, yes, of course. I'm trying to make a living here too. It's crazy that, but it's like, it's a lot of great stuff.
It's a great resource, Dan. I mean, you've been doing great work for so many years, and with TLU On Demand, it's fantastic for all lawyers to check out. What an amazing wealth of information. And we're super excited for TLU Vegas. And we're really looking forward to it. It's going to be a lot of fun and some fantastic speakers. So we couldn't be more thrilled.
Cool. I can't wait. All right, Lucas, I'll see you soon. Take care.
Thanks
Actually,
so
I'm going to be in LA. We're doing a party September 19th that your firm's co-hosting at Nick and Steph Steakhouse in downtown LA. I just sent you the invite. So that's going to be awesome. So we see each other then.
One of my favorites. I'll see you there, bro.
All right.
Thanks, buddy. Talk to you.
Ready to train with the Titans and set records with your verdicts? Register for our live conferences and boot camps at triallawyersuniversity.com. Start getting your reps in before the big event by going to tluondemand.com to gain instant access to live lectures, case analysis, and skills training videos from the trial lawyer champions you love and respect, as well as pleadings, transcripts, PowerPoints, and notes for a roadmap to victory. Join the group that continues to get extraordinary results. Trial Lawyers University, produced and powered by LawPods.